in all different industries as well. So I'll get us started. I'm hoping that, we're going to have a lot of questions. I'm going to be able to provide a little bit of support through this webinar as well. If you do have any questions, please pop them in the chat and then we will get to them at the end. As David said, we'll stop the recording for the questions at the end, just so you've got a little bit of a safe space to ask anything that you need to. So today, the Employment Rights Act 2025. We're going to have a look at what that means for social care providers, and that includes domiciliary care, supported living, residential homes, community-based services. So whilst the legal changes are national, the operational impact will differ by setting, and we're going to reflect that throughout. So a little bit of an introduction to me, very briefly. So as I said, my name is Josie Onions. I get remembered because of the onions, I think, and I am CIPD Level 5 qualified. I have 5 years experience in HR, but I have over 12 years experience of leading people and teams. I am a specialist in complex employee relations, so all of your capability processes, disciplinaries, all of those wild things that happen that you think, what on earth's going on? I help with those. I'm an expert advisor to small, medium enterprises on risk-aware HR strategy, and I have a broad HR generalist knowledge. So that means I don't sort of focus on one single area of HR. I like to have a broad knowledge across the whole of the HR offering. So we're not going to have a break within this session. It should only last between an hour and an hour and a half. We've got the half hour at the end for questions. If you need to have a quick comfort break or anything like that, as we said, this is being recorded, so please do. It's absolutely fine. You can always review the recording afterwards. If you have any questions, please ask these and just stay engaged throughout the session. Okay, so today we're going to look at the changes shaping recruitment and retention, how staffing and service delivery will feel to workers, the union reforms and the staff voice, that's quite a large one. We're having a look at fair pay agreements and the labour market impact. And we're going to have a look at the CQC expectations and what that means for your employer brand. And then the actions that we need to take. We're going to have an action list ready for you. So just a little quick question, and if you want to just pop in the chat a number, on the scale of 1 to 10, how confident are you with these upcoming changes? So 1 will be not confident at all, I didn't even know there were changes. And 10 will be, we've got this, we're just making sure that we're completely happy with how these changes are happening, but we're really, really confident with what's going on. If you just want to, if you're comfortable to, just pop a quick number in that chat so I can see where we're up to. Okay, so we've got a couple of 5s and 6s. That's really good to hear. Fab, so you knew the changes were happening, but you're thinking, what do we need to do practically? What does that mean for us? I need some practical actions that I can take to make sure that we're ready. Wonderful, thank you for that. So let's have a look at why this matters. So what we're seeing with the Employment Rights Act reform, it isn't just a series of small technical legal changes. Taken together, these reforms represent a fairly significant shift in the balance of the employment rights in the UK, and they will change how you manage your people on a day-to-day basis. So there's 3 main reasons why this matters for you. The first one, so the coverage widens. So first of all, more workers will qualify for employment protections earlier in their employment. So this is the statutory sick pay becoming available from day 1, the removal of the waiting days for this statutory sick pay, and paternity leave, unpaid parental leave, they become day 1 rights too. And these changes mean that entitlements that previously required qualifying service, so previously required either that 4 days waiting period or they required the 26 weeks, they now qualify for immediately. So this means that you need to update your policies, your payroll processes need to adjust, and your managers need to understand these new rights that previously wouldn't have applied until later in that employment. So for organisations with a high turnover, this could have a particularly noticeable impact for you. So the second reason why this matters is the enforcement strengthens, and this is a big shift. So the government is introducing a new enforcement body called the Fair Work Agency, which will bring together a number of existing functions. So in practice, this means that enforcement becomes more proactive than purely complaint driven. Historically, many employment rights, they were only enforced if that employee raised a tribunal claim or the worker made a complaint. It was very much reliant on the worker knowing their own rights and having the confidence to bring that forwards and bring that complaint forwards, and sometimes having the money to as well. So the intention with the Fair Work Agency is that there will be greater investigation powers and a stronger oversight for compliance, and they will cover minimum wage, holiday pay, statutory sick pay, and workers' rights. The third reason why this matters is an early employment becomes a higher risk. So previously, where you had 2 years before they had a claim for unfair dismissal, we're talking about this with a lot of clients. And historically, we've relied on that 2-year unfair dismissal qualifying period to make that employment less risky. However, this means that the legal risk associated with the dismissals increases significantly. So the reforms reduce that qualifying period to 6 months, and this changes that dynamic quite a lot. So the impact of this the impact of the Employment Rights Act is the sickness levels will increase. High sickness within your business will be amplified through additional cost, and that's through the additional SSP payments. And that's a possible increase as well in short-term absences. If that employee knows they're going to get some money for that day, they may just think, okay, I will call in sick today, rather than having to lose that 3 days of pay. The pressure on heavy reliance of how paid workers may be amplified through a lower earning limit being removed. And the Act is also designed to give low paid variable hours labour more predictability, more protection. So if your business model works on being able to call in for last minute shifts or to cancel shifts at short notice, then that framework, it makes it more expensive to do so. So recruitment and retention becomes more challenging as timing on the right to claim unfair dismissal is reduced, and getting recruitment right, proactive probation management, it becomes more prominent. So employers with weaker practices may struggle against these and with a more credible employee experience. There will be an increased regulatory scrutiny as the Fair Work Agency is established. And this Act, the Employment Act 2025, it makes HR practice more visible and more consequential. So the compliance is becoming more closely tied to regulatory credibility, and it's not just a tribunal risk anymore. So tightening the operating margins will feel a greater pressure, and through increased risk from the elements discussed. For low margin employers, even if claims are rare, they need to invest in manager training, HR process, workforce planning, and record keeping become an unavoidable overhead. And then the last sort of overview before we get into the nitty gritty of each of these things that I've spoken about is the timeline that we're working from. So April 2026, and it's very, very close now. So 6th of April, these reforms start coming in. It's the SSP changes, the right to parental leave, the redundancy consultation and union access. From October this year, there is a major overhaul. So this is the implementation of some additional dismissal rights, predictable working patterns, and harassment enforcement. And this staggered timeline is intended to allow employers to adapt, but this enforcement will be firm once that date passes. So what we're planning here is we're planning a journey where we need an action plan and we need waves of these changes. We're not planning a single event. Okay, so statutory sick pay reform. This is in on the 6th of April, this changes. And the removal of the waiting days, this, as we can all probably guess, it may increase that short-term absence reporting. And the impact will differ depending on your setting. So, for example, if you're in domiciliary care, you may have disrupted visits, you may have travel rearrangements. If you're in residential or supported living, you may see a higher agency on agency staff and an increased shift pressure. If you're a small service, you may have a higher pressure on the registered manager or on-call cover. And it's important just to let you know that the lower earning limit has been removed, but that rate will be an 80% average of the weekly earnings, or that standard statutory sick pay rate, and whichever is lower. So for those people that earn below that rate that they would get on the normal SSP. And the implication for this is higher cost. And just to put this into some figures to think about. So if on average your business has one person off per week for one day, that can amount to just under £1,300 per year in additional sick pay. So if you're thinking, oh, actually, on average, we have two people off for one day, we have 2 lost days in that week. Of course, that increases to just under £2,600 per year in additional. So just to put it into some figures for you, so you can have a look at what you may be looking at after this sick pay is introduced. Again, from the 6th of April, we have immediate access to parental and paternity rights. So we have parental leave eligible after 1 year service at the moment, and paternity leave eligible after 26 weeks service at the moment. That's coming away. So these are available from day one. There is also an introduction of another type of leave called bereaved partners paternity leave, and this will be a day one right too. This is if the mother or the main adopter passes away, the person who was going to take paternity leave is now entitled to take 52 weeks of, and this is important, unpaid leave to care for that child. So this can have a positive impact on your recruitment, especially for a younger workforce or parents returning to work to be able to take that parental leave immediately rather than having to wait that 12 months. That could have a positive impact. And they still have to give notice to take parental leave, and it is an unpaid leave. It's not for the paid leave for both of these, and that's really important for you to know. So what you'll want to do is communicate flexibility clearly and communicate these rights through your recruitment, as it may be able to give you an advantage. So the Fair Work Agency is established. It has come into play, it has started, and it's currently being put together. So we are starting to see a little bit of the impact of the Fair Work Agency already. But the Fair Work Agency is a new enforcement body which is consolidating these powers that already exist. So they will look at national minimum wage, holiday pay, sick pay, and family rights. What you need to have in place for this is consistent records, as inconsistent records can create a liability risk. Poor employment practice will damage your recruitment reputation faster, and we've already seen the outcome of this Fair Work Agency being put together. So I have already seen letters being sent to employees and to employers to check that they're being paid the national minimum wage. It's a letter from the HMRC at the moment. It doesn't have Fair Work Agency on there, but it's to encourage employers to check their practices and to encourage employees and ask them a certain amount of questions. And it's to say, do you have to, for example, pay for your own uniform? Do you have travel between your jobs? Do you have travel between, the people that you go and visit? If so, you could be being paid under the national minimum wage. Do this calculation to check. And this is naturally something that's come out of this Fair Work Agency being put together. So the Fair Work Agency will not need a report to inspect the organisation. They can investigate and enforce without waiting for an individual tribunal claim.
Sorry, Josie, we've got a question of who ultimately pays SSP.
The employer is responsible for paying SSP. Sorry, it feels like quite a short answer. If there's anything else on that, please let me know, but it is the employer's responsibility. Okay, no problem. So the implications of this Fair Work Agency. So this is proactive enforcement, and investigations can be initiated without a worker complaint. So they can come in and inspect, they may act on intelligence data or trends that it identifies and not just individual reports. Just to let you know, I have seen the question come through. We'll just save it there and then come to it at the end, if that's okay. So the investigations can be initiated without a worker complaint. So you don't need to wait for someone to understand that they've not been paid properly, for example, or wait for someone to investigate themselves. The Fair Work Agency can come in and investigate your documentation and look retrospectively as well, so they can look back on your records. This means that you must maintain consistent compliance at all times and not just respond when an issue arises. You must also have your trails, your robust audit trails in place as well. It increases the financial and reputational risk. So non-compliance can result in fines, enforcement notices, and public naming. I don't know if anyone has seen, but there has been a business in the news recently that are a childcare provider, and they have been underpaying their staff. They've not been paying them national minimum wage, and they're in the news. It's very big news, and it's very obvious who that is. I won't say it on the video, however, it is in the news at the moment. So it's just one to be aware of, because obviously that affects their reputation quite heavily. You need to ensure that your payroll, holiday records, and absence reporting and other HR systems are accurate and auditable. Do you have them? Do you have a HR system? Do you have a payroll system that you can look back on for up to the previous 6 years and make sure that your records and people's holidays have been recorded accurately, and you know when they took holiday, and you know the calculation that was used for their holiday pay as well? That's really important to be able to reference back to. So there's likely going to be an overlap with other regulators. So Health and Safety Executive and obviously CQC may also be involved in compliance enforcement. So we'd just encourage you to fix those basics before any major recruitment drives, and promote transparency as well through your business. Right, I'm going to take a little drink before this one because it is quite a lot of information. So hold on to your boots. Trade union reforms. There's a lot happening with trade union reforms. You may have a trade union, you may already be unionised, or you may not be unionised. Either way, you do need to know the implications of these reforms. So the first one that's already in, so came in February, is there's a shorter notice for industrial action. So this means that instead of having to give 14 days notice, they now need to give 10. This is your contingency window shrinking. It means that you need to have robust rota planning. You need to have bank cover routes, maybe have like an action pack that you can go to, agency escalation. You need to understand how you will communicate with your clients or the families, and the commissioner notifications may need to happen faster. So if you operate a regulated service, which you do, you'll want a rapid response plan, because continuity of service, it's a safeguarding issue, and not just a business disruption. So what can you do with this? Build a 10-day strike response checklist. So have a staffing escalation ladder, a minimum safe staffing assessment in place, a service prioritization, and comms scripts as well, so communication scripts. You will want the industrial action ballot mandate lasts 12 months now and not 6. So this means that a dispute can stay live for longer. You may see some intermittent action over a year, which is harder to deal with operationally than it is with a single burst. And ongoing uncertainty, of course, it can affect your recruitment and retention as well. So what can you do with this? What are your practical actions to take? We would recommend to plan for a longer horizon. So budget assumptions, agency framework agreements, and proactive employee relations. Your best form of defence and your best proactive step that you can take is having a good relationship with your employees, listening to them, and having that transparency. There's going to be less procedural friction, so the need for a picket supervisor requirement is removed. And what this means is there are fewer technical tripwires that previously reduced the likelihood of lawful action going ahead. So for you, the key operational impact is that industrial action becomes easier to organise and sustain, so early engagement matters more. That's the changes that have already happened. From the 6th of April 2026, further changes are that recognition becomes easier. So if you're thinking, well, we're not unionised, so this is all okay. It is at the moment. However, recognition is going to become easier to come into your business. So what this means is if you have a dispersed workforce, for example, you have multiple sites or you have community staff, recognition campaigns may become more visible because the barriers are now lower. In real terms, this is the percentage of eligible employees voting yes has been removed. So previously, the amount of employees voting, it had to be over 50% of the eligible employees who could vote. Over 50% of that number had to vote yes. However, this has been taken away. And for example, if you have a staff of 30 people, if 3 people were to vote on recognising a union, but only 2 people in that vote voted yes, your business may now recognise a union for bargaining purposes. And that's what that means in real terms. So you could have a very low turnout of voting. You could have a very low number of people vote yes, and you may now recognise a union because of that vote. So once a union is recognised, you may need to negotiate collectively on core areas. So this is commonly your pay, hours, and holidays. This can affect your rota patterns, overtime controls, your pay differentials between your senior carers, your nights and your weekends. It can affect your travel time pay, sleeping arrangements, if that's relevant to you. So what we would recommend with this is to get ahead of typical pain points in care. So pay progression, travel time, training time, cancellation of shifts, fairness in rotas, workload and supervision is talk to your staff, talk to your employees, understand where the pain points are and work together so that they are less painful. So August 2026, we have electronic and workplace balloting. So this means that ballots can run more effectively, which can increase participation and speed up union processes. So for you guys, for care where staff are often off-site or on shifts, easier balloting means that it can be more effective organising can take place. So what we need to focus on less is the ballot mechanics and more on the fundamentals. So that's your manager behaviour, consistent decision making and some credible consultations when making changes or proposing different things for the staff. And October 2026. So workplace access, union reps' rights and the duty to inform. And this is the biggest day-to-day process wave of changes. So number one, the duty to inform workers of the right to join a union. You'll need to build this into your onboarding packs. You'll need to build this into your induction checklists, and you'll need to acknowledge this within your handbook. So where turnover can be high, this can be an ongoing operational admin step, but it is manageable if standardised. So if you have a small section in your employee handbook and in your onboarding paperwork where you maybe send a welcome pack, you have a little bit in there to say, make them aware of their right to join a union. You've got it sorted. It's just making sure that that's in place. Sorry, was there a question? Oh, that's fine. I just heard someone. Okay. Strengthened union right of access to the workplace. Now, this is really complex. Can be really complex in care because a workplace can mean so many different things. So it could be multiple homes. It could be community carers who start shifts from home. It could be a client premises where access may not be yours to grant. And these are all things that you'll need to have a think about and ensure that you just have a plan in place and that your managers are trained on this. So you can expect more formal access requests and you'll need some rules in place. So where meetings can happen, you could have it set as, for example, a staff room or a training room, when they can happen. So does it need to be during breaks, just before or just after shift? And how digital access works. So are they allowed to access your team through Teams, through WhatsApp groups? That could be really sensitive. So you want to have some ground rules in place of how you will operate. So some practical actions as promised for you to take. So where union access protocols need to be tailored to care. So this may be separate rules for care home sites versus domiciliary or community care. You need to have some confidentiality controls in place. Have a think about your visitor, DBS, site security expectations, and ensuring that there is no disruption. So, for medication rounds and for handovers, these need to be protected times and make sure that these aren't disrupted by union access. You will also be expected to provide reasonable facilities and accommodation for union reps. Excuse me. So this may be a private space for meetings, a notice board where they can put materials on, or an intranet space, and then time to perform their duties as well if you have a union rep on your workforce. And space may be limited, so facilities, this may be digital facilities rather than physical facilities, but it does lend itself to be able to take that into account as well. And you'll be expected to give paid time off for union equality reps. So you'd need to plan this into your resourcing, into your rota, and even modest paid time off can create a knock-on cover need. I said it was a big one. Okay. So just some things that you may see and the likely pressure points. So day to day, if you're already unionised, or if you have you've become unionised in the future, you probably won't notice too much day to day. It's not going to have a huge impact. However, the impact will come when it comes to a pay review, or when the rota changes, or when there's a restructure, or when your workload increases, or there's a disciplinary. You may find yourself consulting with a union representative, and you'll need to make sure that you have clear processes, you have trained managers, and you have an open culture as well. The likely pressure points is if you cancel a shift at short notice, or if there's perceived favouritism in the rota, your pay differentials between your staff, so your nights, your weekends, and your senior carers. If you pay training time, if it's paid or unpaid. of your paid travel time as well, and your manager behaviour as well. So you need to make sure that you've got consistency and manager training with that as well. So your biggest operational risk is not that a union exists, it's that disputes can escalate quickly and you have less time to stabilise staff, and you have less time to reassure your commissioners and families as well. Okay, another big change that came in. So since October 2024, you have had a statutory obligation to take reasonable steps to prevent sexual harassment in the workplace. So what are reasonable steps? And this is a question that we get asked quite often, and this is what we work on a lot of clients with. And it can differ depending on the size of your business, depending on the nature of your business. The standard things that we would say that are reasonable steps are to have a solid policy which is tailored to your business. So not an off-the-shelf policy. It's one that we've sat down and discussed and made sure that it's suitable for you. It's having a risk assessment in place, and also having manager training and staff training as well on preventing harassment. So the law has shifted the focus towards the prevention. It's proactive prevention of sexual harassment and taking steps to reduce it rather than simply responding if a complaint arises. So we need to make sure that staff complaints are taken seriously and they know how to raise them as well. And the key point here is to ensure that that duty is proactive and not reactive. So it's not enough to say that, no one's complained, so we assumed everything was fine. If there is a complaint, you need to show that you've already taken those steps. So if you are sitting there thinking, oh, we haven't got a sexual harassment policy, we've got a bullying and harassment one, but we haven't got one that mentions sexual harassment, or we haven't got a risk assessment in place, or we haven't done any staff training, then you're not alone. It happens quite a bit, so please don't feel uncomfortable about coming forward and asking for some support. That's something that we support many clients on. So from the 1st of October 2026, it goes from when it was in 2024 to taking reasonable steps. It now goes to all reasonable steps. So it's been strengthened as of October 2026. As you will see just on the bottom of the slide, in 2027, we will find out what all reasonable steps are. It hasn't been finalised and it hasn't been spelled out in black and white what these reasonable steps are. However, through tribunals that have already come about and through what we've seen, we have a pretty good idea of what these reasonable steps will be. We've also got the important factor of having the proactive duty to prevent third-party harassment. So this may be clients, patients, service users, contractors, families, members of the public, and it's important that you consider how you protect your staff from inappropriate behaviour from third parties and not just colleagues. And again, this will involve things like clear reporting routes, management intervention, signage being up. So if you're running a care home, we'd expect to see some signage up for members of the public or for families, contractors to see as they walk in, outlining those behavioural expectations, or removing employees from situations where harassment is occurring. So from a practical HR perspective, we advise that organisations treat this as not just a culture, treat this as a culture and risk management issue and not just a policy update. It's intended to be, and it is a lot more than that. The organisations that are most exposed to risk are often those where the policies exist, but staff don't know about them. So have they been published? Have they been talked about? Do you talk about the policies in staff meetings? Do you talk about them in one-to-ones? Do you check that your staff are aware of how to report sexual harassment? Places will be at risk if managers aren't confident in handling complaints. If someone brings a complaint to them and they say, oh, well, just let me know if it happens again, that is something that could put your business at risk. If you did some training, but it hasn't been refreshed since October 2024, for example. And tribunals will increasingly ask, what steps did the employer actually take to prevent harassment? So if you sort of think, well, I mean, we have a grievance policy, but that's really all I could say right now. Ask us for some support and we can support you on that. So the documentation, training and leadership behaviour all become really important evidence. Really important that you've got it documented that you've taken these steps. And one of the most common issues that we see when supporting organisations with these harassment complaints is that managers feel unsure about intervening early. But the expectation is that employees create an environment where inappropriate behaviour is addressed early and confidently, rather than escalating it into a formal grievance or tribunal claim. So if your managers are confident and you have intervened early and they have said, oh, actually, no, let's sort this out, document it, evidence it, and keep it on file to make sure that you can reflect back in, say, 2 years to come if a complaint ever comes about, and you can say, well, we have taken these steps, look at this evidence. That's really important as well. Okay, this is a big one. This is one that we've talked about a lot, and is probably one of the most prominent updates within the Employment Rights Act. And that is reducing that unfair dismissal from 2 years down to 6 months. So, as you may know, and as you probably do know already, that most employees need 2 years continuous service before they gain the right to bring a claim of ordinary unfair dismissal. So under the proposed reforms, this qualifying period is reduced to 6 months. This is a practical effective change that employees will gain protection much earlier in their employment. So why is this so significant? So it's been used as a bit of a buffer period historically for most organisations. And in practice, it meant that if employment wasn't working out, employers had more flexibility to bring that employment to an end during the first couple of years, providing that dismissal wasn't discriminatory or automatically unfair. So this increases the risk of employment. It increases the risk of that recruitment. But if you have clear processes, then it doesn't. It's about having those clear and documented processes in place, and then actually it doesn't increase your risk at all. It's where it may have been a little bit more informal through that probation management. That's where the risk comes in. And it's going to be really, really key to have formal probation management, early performance conversations, and documentation of concerns. So what I see often with a lot of my clients that I've worked with in the past is that probationary periods, they exist. You have a probationary policy, but they're often managed quite informally. So you will come to sort of the 6 month period and the manager will want to end that probationary period because it's not worked out. However, there haven't been any conversations in between, or there've been informal verbal conversations with no documentation to back it up. So under the new framework, it becomes much more risky, because once that 6 month service is reached, employees will have the right to challenge the dismissal as unfair if the correct processes haven't been followed. So the biggest risk here is manager behaviour. It isn't legal complexity. And many organisations still treat early months of employment as relatively informal, with issues addressed casually or sometimes not even addressed at all. But once that period drops, then it's going to be much more important on how we manage that probationary period. And the organisations that adapt well to this change will be the ones that manage that probationary period actively, address concerns early, and ensure that managers are confident in having those performance conversations. So there's two folds to this, because what you don't want to happen is that you get to sort of that 6 month period and you actually have someone in your business that may not be the best fit. And you can still go through a fair process, but it's a longer one, it's a bit more of a lengthy process. Whereas if you actually have this formal probation management, you have these conversations with your employee, you share any concerns and they get that feedback and they can respond and improve, actually, you've probably got a more successful employee there. And if they're not, then you have a documented process of how that employee's probation has been terminated and you have reduced that risk for your business. So what can you do to get ready? So manager training, fair processes and communication strategy. So you want to promote your staff voice, share good practice case studies together. And where your activity may focus is on that mileage and travel time, on your shift patterns, on short notice rota changes, your pay parity, but just make sure that you have these things in place and you've considered them, and then that will get you ready for the upcoming changes. Fair pay agreements. So it's really important that these aren't live yet, but they are coming and they are starting with adult social care. That's been confirmed. So the fair pay agreement is expected to set minimum pay and conditions across the whole sector. So that means that providers won't be able to compete by lowering terms. The biggest impact here will be on your cost and workforce planning and not with immediate policy changes. So there is quite a few changes that do need immediate policy changes. This isn't one of them. However, you do need to be aware of it and be ready for it, because if the sector pay floor emerges, pay is going to be less of a differentiator, and your recruitment will depend on your culture, your progression and well-being. So what can you do? The first thing that we would recommend that you do is financial scenario planning. So we're going to expect an upward pressure on hourly rates, potentially sick pay, that could happen, training and development standards, and just start modelling some scenarios. So what if pay increases by £1 per hour? What if it's £2 per hour? And just have a look at these different things that may happen. Ask yourself the question, can your current fee rates absorb that? Do you need to have a look at your pay structure? So map out where your care staff pay is, your senior roles and your management pay. Because when the minimum rates go up, what often happens is like a pay compression. So your entry level roles increase, but your senior roles don't move at the same pace. And then all of a sudden you can have very little difference between them. Another thing that we would recommend is to strengthen your retention beyond pay. So if the fair pay agreement standardises pay across the sector, you can lose a key lever in your recruitment standards if you can't compete on pay in the same way. So your question becomes, why would someone choose to work for you? So consider that career progression, flexible working, your quality of management and your workplace culture. And then lastly, be ready to act quickly. So once agreed, this is likely to apply fairly quickly. So make sure that someone in your organisation is tracking the updates. Be ready to review your contracts, pay and communications at a decent pace. However, I really want to make sure that you understand that 2026 is the setup phase. Okay, so this hasn't come in yet. 2026 is setup phase. 2027 is likely to be the negotiation phase, and 2028 is likely to be the implementation. So definitely be aware of it. Start looking at those contracts, looking at that financial planning and scenarios, and have that plan in place ready to come back to when you need to. So just a little recap on October 2026 and beyond. So the shorter unfair dismissal period, there's going to be increased protections around shift changes and contracts, with stronger rights. Poor probation experiences spread quickly, and that can damage your brand, your employer brand, and we need to support providers to improve induction and line manager skills. So there was quite a lot around banning 0-hour contracts. That's not happening. However, there will be reform. So what will come in is the obligation to offer 0 hours or agency workers and minimum hours. There's secondary legislation that's coming in. It hasn't been confirmed on what that reference period is. How many hours you have to work until you're offered that, or how long you have to work, or what that minimum may be. Could it be a percentage of their average worked hours over the past 12 weeks? All of these things. But there isn't a ban on them. It's just a reform. So what do we need to have in place? So inspection ready is recruitment ready. These are good practices to have, and it affects your brand, your employer brand, and how successfully you may bring people in and retain them. So you may be asked for staffing risk assessments, for if there is union action. You may be asked for your pay and travel compliance from the Fair Work Agency. You may need to have evidence of those lawful pay practices. You'll want absent management processes and fair ones in place. Your staff engagement mechanisms. This is really important to, aid you with any union engagement. If you already have a good relationship with your staff and they're happy, you're less likely to have the need for the union to come in and negotiate on their behalf. And your supervision and probation documentation to ensure that you're covering that compliance within those first few months of employment. And then your immediate actions to take. So have an audit of your pay practices. That's your travel time, and community services. That's your sleep-in rates for residential and supported living, making sure that you've got correct holiday pay calculations. So for irregular hours workers, 0 hours employees, how do you calculate their holiday pay, and is it compliant? Having a look at your usage of 0 hours staff. You'll want to strengthen your absence management, so have clear trigger points, have structured return to work conversations, and have those contingency staffing plans in place, and monitor your trends as well. So if you have lots of short-term absence already, you may want to strengthen those processes and formalise them quicker to reduce that cost implication on the business. You want to formalise your probation processes. So do you have clear objectives? Do you have documented reviews? Is there early intervention? Do you have clear training records? Could you go back and say, yes, we gave this person every single opportunity to be supported to pass their probation? Improve your staff voice mechanisms. So do you have regular staff forums? Do you have anonymised feedback routes? Do you have clear grievance handling procedures and a transparent rota communication? And then finally, aligning your workforce strategy with your recruitment messaging. So through your adverts, do you promote your day one rights? Do you highlight flexibility and flexible working? Do you demonstrate that you have fair pay practices? And can you show evidence of your supportive leadership within your business? Okay. So if I've come to the end of here and you're thinking, oh no, we haven't got these things in place, we are offering a free HR health check to anyone that is on this webinar. So you can either get in touch with me, and my email should be on the invite, or if you wish to scan that QR code, that will take you through to our communication, so you can contact us through any of the routes on there and just say that you're on the webinar and you want to have a discussion about the free HR health check. So I think what we just need to understand is that this isn't about causing chaos. It's about the fact that we need to just have a clear plan in place, have that structured approach to these updates, and as we said, ask the questions, feel free. It's a safe space. I think the recording's probably going to stop relatively soon, ready for the questions that are coming in. And thank you.